Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
And welcome to Justice Served TV. We are on the air. Michael Bryant here. Hey, Linda Kenny Bodden.
Hi. By the way, Tubi thanks the Justice Served TV crew for that birthday celebration at the end of the day and the song by Oasis Cat. And then he was very happy to get off my lap and go play with his toys and then start barking at me because, like, what did you do to me, Mom? I want to go play. I mean,
That's right.
you know, you're making me stand there and be a statue and
Not a lap dog.
a dog sex symbol, you know, what am I,
That was very good. Oasis Cat put that together, and that was very cool.
It's gorgeous.
4 years old. 4 years old.
I know.
Tubi, not Oasis Cat.
Right.
So, hey, we figured today that we would talk with some of the folks on the ground there in Canton because of this new issue with the buffer zone, which I'm now calling the First Amendment zone. No longer am I calling it the buffer zone.
Oh, that's
First
great.
Amendment zone.
Oh, wow.
And because it still exists. The signage is still there, but now the rules have changed. And the real question is who's going to follow the rules? Curious. So we thought we'd talk to a couple of folks who are going to be there. Since I couldn't be there at this time, I'll be there next week to kind of test the waters myself. But for those who don't know, an order was issued by Judge C because she was told to by the appellate court. They gave her 48 hours to come up with some sort of decision after they slapped down her original rules on the buffer zone. So the order is a supplemental order. The buffer zone still in place, but the First Amendment zone is now open for most activities, I will say. And I think it's best to take a look at the document itself, because we can talk then about the vagueness and where the problems, I think, are definitely going to come in. So this is now the supplemental order.
Okay. And
I've just jumped down. We'll go ahead and spend a minute or so getting to it. We get Tom and Scott to find us. So this comes, as you can see, from the Superior Court. I just heard somebody blink on.
Yeah.
The court is in receipt of the decision, which was the slap your ass down decision, the Grant case.
What did you call it? Sorry, what did you call it?
Slap your ass down decision. Okay. Judge Cannone, sit down. To simplify any potential First Amendment issues related to the buffer zone restrictions implemented by prior orders, this court, guided by the Court of Appeals suggestion set out on page 12 of the decision, and that was from the Circuit Court, issues the following supplemental order. First, all the reasons cited in support of prior orders are based on the parameters of the dispute as narrowed and described in the decision. All orders of this court remain in place in as far as they apply to courthouse property. So she's making that distinction. Now, nobody was trying to storm the courthouse, all right? Second, prior orders remain in place as applied to pathways, including public sidewalks and roads, through which and at which time trial participants enter and exit. So she's sort of carving out another area which she has zero jurisdiction over, the public sidewalk right in front of the courthouse.
Right.
This is, and I talked to Mark specifically about this. You got to check out the interview I did with him when we get done here. And I said, so we can go right up, and I'm using the royal we because I've been doing it already. But, we can get right up to the steps as we were before, as long as we're not impeding traffic. And he said, yeah, that's what it is. Third, noisy protests, including those using amplified sound, honking horns, or loud screaming and yelling that are intended to interfere with the administration of justice, intended to interfere, right? Or are intended to influence any judge, juror, witness, or court officer in the discharge of his or her duties are prohibited within the First Amendment zone. Fourth, the display of written or graphic materials that are intended to interfere with the administration of justice or are intended to influence any judge, juror, witness, or court officer in the discharge of their duties are prohibited within the First Amendment zone. I think you got a problem right there. I think you're going to have a problem. So she's basically saying, okay, if you're in there, you better not have these protest materials on. Well, that was the first order. The difference was you couldn't even traverse the area or be standing in the area, as I found out when a trooper approached me. You got to keep moving, keep moving. So I think you got a problem right there, because she's basically saying, okay, you can come into the zone, but you better not have any of your accoutrement on. That's not what Marx is
That's
about.
the whole point. The whole point is that you can have the accoutrement on, as long as you're not
Of
intending to
course.
influence. You can protest. You can say, free Karen Reed. This place is a joke. Norfolk is for hire. The fix was in. You can say all that. I mean,
Yes.
you can say right.
And so they have to interpret that you are intending to interfere with the administration of justice, or you're intending to influence.
Right. Right.
They're just speaking their mind in support of one of the people. So again, these are going to come to a head. These are problems. I can see it already. Fifth, which was a bonus that Mark said they never even asked for, but it's a judicial remedy. Fifth, any person whose activity has been restricted by an officer enforcing this order may request review by a judge of the Superior Court, which request shall be heard as expeditiously as possible, whatever that means. And then so you get to the very end. Quiet off-site demonstrations, and again, the site is the courthouse. Off-site demonstrations on public property in areas and at times that do not interfere with the trial participants' entrance into or exit from the courthouse, and that do not interfere with the orderly administration of justice, and that are not intended to influence any trial participants in the discharge of their duties, are specifically outside the scope of the First Amendment zone restrictions.
So, I mean, the good faith of the police is going to be important here, right?
Of course.
Their good faith. And quite frankly, from what we've seen in the courtroom, the good faith of the Commonwealth is, after we saw today with and we'll talk about it after, the motion to change their whole theory and timing of the case now. Imagine if the defense did this. I mean, so I think there's two standards going on here everywhere, and we'll see if there's two standards that people are going to pay attention now that they know that at least the federal courts are listening, right?
I think the federal court did a great job. There's no doubt, and they actually have given Judge C an opportunity to fix things. The question is, does this fix things, or does it muddy the waters? Does it open the door a crack, and then she's just hoping somebody pushes through it and gets arrested, because then she can assume, well, you intended to disrupt, prevent, slow down, all of the things you're not supposed to do.
So right here, they can close all the sidewalks in front of the courthouse because somebody may be going in on there. They usually go in on the left side. Everyone goes in on that one side, right?
They all come in right. They go up the handicapable ramp, right? But it's the front of the courthouse. They just haven't used the stairs lately because they all have all their trial briefs and brief cases, and it's a lot. So they come zigzagging down or up the handicap ramps. And so that I don't expect to change. And it's right there. And there's a sidewalk that's right there. It's the place where I've done the Karen Reed Q&A and where the other press is. So the question is that going to be barred as well for anybody else? I don't know. We don't know yet. But to me, these are huge questions because it seems to me they're almost baiting people to come on in, come on, and then let's see what they do.
Yeah, and all she needed to do, and I thought initially when I saw this, it went back to the prior zone of last year, which worked pretty well, right? There was no issues. No issues at all. But she didn't do that, right?
No,
she's not going to give an inch.
The First Amendment zone is still in place, but you can do certain things within it, but not other things, and it's subject to interpretation, and perhaps it's going to be the troopers that are interpreting. No, this is a mess waiting to happen. But that's okay. I mean, it's part of the process, but they could have done worse. The federal court could have sat on this like a pocket veto and done nothing.
Oh,
right?
like our judiciously press pass that we've had three emails in, two of which not been responded. The very nice man you said at the court, and they're so quick in giving you some kind of relief.
Oh, hello. Oh no, that's not them. I thought it might be them. Yeah. No, not a word from them. So I don't expect to hear any from Jennifer Donahue. Okay, right. If you want to send her a note, it's jennifer.donahue at gosh, I want to make sure they have one of those. Every time the government's involved, they have this weird extension, right?
Yeah, mass.gov.
Yeah, is that the right mass.gov?
Oh,
hey Tom.
Hey,
there's actually it's a further extension than that. The last part, it's state. I think state is in there too. So it's mass.state, meaning st.gov. So Jennifer, normal spelling, not like Lucifer, Jennifer.Donahue at ma.st.gov. So send her a note, tell her I said hi. So Tom, you got this paperwork. You took a look at it. What are your thoughts?
Well, the easiest thing for Bev to do is just go back to the way it was last year, and that was still the troopers were still kind of pushy and bossy last year, but I think this year they're gonna lighten up. Now that we got this order, they can't. I don't think they have it in them to push us around anymore.
That's what I can't wait to see, because it's not exactly worded cleanly. I'll tell you that.
I mean, what they did to Erica was above the pale.
Of course,
There's absolutely no need for that, and that's how they were trying to rule that buffer zone, because they were in control of that. They're not in control of that now. That area that we were not allowed in, we'll say. Now we are.
Yeah.
So, and we've always behaved when we've been inside that. No one's ever gotten hurt. People, the reporters, like the guys with the cameras, have knocked people down, but like no one's really gotten hurt. We've been orderly. So this whole order is, they're making more work for themselves. They really are.
I think they're setting themselves up. Are you going to be there tomorrow?
Absolutely.
All right, because you've been there, and then at 8 o'clock, when they've basically told you, shoo, run along, that's when you've left. But now you're going to stick around.
I'm all day now. Yep, we're going to get Karen walking in and walking out, because that's kind of what started this whole thing, right? Is me walking in and walking out with her every morning. And it went around the world. It was global. I had people from around the planet watching her walk in the court. So, and it's kind of funny, because what else is, I would get raw footage of either Karen or Alan or Liza or whoever it was talking to the press. I'd get the entire conversation, so my viewers would hear it all. By the time it got to the news, it's like a 2-second segment, like a clip, and it's not even close to what they were saying. So my viewers and our viewers, all of us, we all now get to see in for ourselves what Karen says, what her attorneys say, what other people say. We're going to get to hear that, and you guys are going to hear it unimpeded by anything. And I think that people deserve that. They've been with us from the beginning.
Sure.
Yeah, Tommy, so great. I mean, we'll be streaming it. I'll be on about 8:50, but hopefully we'll be streaming a little bit earlier tomorrow. But yeah, we want to see what happens tomorrow. That's going to be a big day, because they're going to have to follow this order now.
And the order is still vague, because it refers back to last year's buffer zone that was vague in itself, because I mean, this buffer zone thing is all new. Where else in the country do you have a buffer zone? I mean, Casey Anthony didn't have it. Scott Peterson didn't have it. I mean, Bernie Madoff didn't have this.
We didn't have it in Phil Spector. We didn't have it in Aaron Hernandez.
I mean,
we didn't have it anywhere. Yeah.
Yep. Just reasonable restrictions to prevent injury, public safety, common sense type stuff, not Gestapo type stuff.
And the sad part is now everybody around the world is seeing how bad and how dirty our system has become. I hate to say that, but the world watching the world watched what happened today.
Yeah.
Can you believe that?
Today was unbelievable.
They watched Kerry Roberts say that she lied to the grand jury. People watch that. What's that send for a message? What does that send out around the world? It's beyond. And yet
it's hard to be high and mighty. The U.S. is supposedly the model.
Leader, right? And then today with these Rule 14 violations, that stops the trial. We're back to square one. We have to start over.
I am outraged about the judge's comment about this. You've tried your whole case. The state is going to rest next week, right? They only have a few more witnesses left. And now they're changing their theories about the witnesses. And you can see by the way she was saying it. Well, Mr. Leslie and Mr. Brennan, when are you going to call them? Can you call this Mr. Leslie? They've changed the whole case. We as the defense, and I say we because I perceive myself as a defense attorney, and I know I'd be Riley man. I would have said, no, Your Honor, we cannot retry our case. I'm sorry.
Where do you even begin? You based your whole entire defense on wrong information that they gave you. How is that their fault?
And it's too bad the prosecution's case is blown up in their face, and this is their way of trying to fix things. You've got to make a record here. With this judge, that all you can do is make a record, because if there is a conviction, I mean, the basis for an appeal is a massive stack of reversible error.
But let me give you an example of changing. When we did Spectre 1, and Alan Jackson will know this, okay? And I'm teleporting. He should think about this. And we got hung, and it was like a 7-5 hung at that point. And the judge went back and said, well, I'm going to recharge him with a brand new theory of the case that no one had ever tried, right? About if there was an earthquake and he was holding the gun and it slipped and it went off in her mouth. And he invited us to give new closing statements on that. We said, we're not doing it. You do whatever you want. We are not part of this, okay? And we object, okay? And he gave the charge. We didn't do anything, and then the jury still hung, okay? So you have to be firm. I mean, I would have said to Leslie, if I were advising them, say, no, there's nothing we can do. There's nothing we can do to repair that damage. We've tried this case based on this, and there's nothing we can do.
I think today at the end of the court, that Rule 14 issue that came up, I think that is bigger than anything we've seen so far. And I got a whole board full of wrong stuff that just can't happen. Yet here we are. And I'm kind of happy that it's happened so everyone can see it. But I'm kind of sad that it's happened so everyone can see it. And I'm kind of embarrassed that it's happening so everyone can see it. But it has to be so we can fix it, because that's the only way it can be fixed.
Tom, it's just, it's the same information, and we're not changing anything. We're not adding anything. Everything is really the same. So I'm not sure what the defense is complaining about. Hanky, I mean, come on, dude.
It's that obvious
what you're trying to do.
Why don't we explain to people, Michael, why don't you were hosting, you were leading, anchoring at that point. What happened?
Here's my best analysis, and that is that the prosecution is trying to rejigger the numbers because it helps their new timeline, because there's been so much information that's adverse to their original timeline. We're just talking about seconds difference, right? Seconds and a minute or so, right? So they're calling the triggering event 12:31 and change. Right. Based on, we have Whiffin's analysis, and then we have what's Accenture? What's the name of the company? What's the name of the company?
Accenture.
It's Aperture, but Aperture is going to use Burgess from Aperture is going to use Whiffin's analysis.
Good idea.
Now Whiffin's new analysis, which has been out there for 3 years, and now change their numbers based on a monotonic clock versus a display time and waves and all sorts of stuff to give them an extra minute so that Karen Reed, I guess, could get home and hook into the Wi-Fi, right?
Yeah. Well, they know that those numbers are so set. The time, according to their own witnesses, that she left, and then with Whiffin's analysis of the phone when it was switched off, right? Had to be a human switching it off, and then she hooks into the Wi-Fi at 12:36. That's a whole hell of a lot happening in about 5 minutes.
5 minutes. What do you think about Higgins in the back parking lot for 5 minutes? What do you think he was doing?
He was moving cars.
Moving cars. You did like ghost cars and stuff, man. You just didn't even see him moving. How's that?
There were some people that said there was
that.
Was there another person in that parking lot with Higgins that night?
We're working on that. Body? We're working on that. We did see another vehicle leave, and we're trying to figure the vehicle out first, because that's going to tell us who, to a point, But I mean, that in itself was like mind blowing, and then we have this today, which is even more mind blowing. And
how about the fact that they call the medical examiner, then when she completely deep sixes their case, they go on and Judge Cannone allows him to redirect her as if she's a hostile witness to them, who they called to get his whole case. And did you consider this? Did you consider that? And she held her ground, but boy, I tell you what, that was outrageous.
They're asking her,
I've never seen that before.
If you've heard of what happened, did you hear her say, I hit him? the medical examiner after the fact.
Yeah,
Like,
but that stuff backfired because the medical examiner, except for the one Jen McCabe reference, the medical examiner said, "Yeah, I knew that stuff. I knew that stuff. I knew that stuff." And then the one Jen McCabe, "Yeah, I don't think I heard that." So what? The damage is done. You're trying to make it sound like she would have had a different opinion had she known all this other information. Well, she knew 90% of it, and she didn't change her opinion. So that's a loss, dude.
Welcome to the United States of Dedham County. You know, and Tom, we got into this case and we just said when we were at the end of the first case, look, I mean, the state has to prove their case beyond a reasonable doubt. And if they do, fine. They've taken this case and they've dug in. They've taken it basically what should have been only charged as a DWI leaving the scene of an accident, right? That was it. That's all the charge should have been. And they dug into it. It's a murder and all this stuff. And now here we are with the second trial. And you have to wonder, and this is somebody who at least people have gotten behind to mount a defense. Look at the normal person. Look at poor Erica Walsh. If this wasn't on camera and there wasn't other things behind, right? Look at what happened to her, right? Look at what would happen to Michael and you. You would have gotten arrested.
And
if
Mr. Delgado.
Mr. Delgado and the 4 other people that are told that they can't even walk down the sidewalk.
Right.
In America.
A Madeira Beach caregiver, Madeira Beach caregiver has been the most amazing person the past couple of days. She has given us a lot of donations for additional likes and subscribes. And by the way, please like and subscribe. My edit view showed Higgins run to car and drive it away. Then minutes later, he appears walking in the lower left frame.
So is that a second person or was that video edited? I mean,
yeah, Madeira Beach. That's really interesting. You had an edit view and it showed that it was edited for that. Isn't that interesting? Thank you again for more of your donations.
Real quick on that note right there, the community and the people that are involved in this case, you cannot compare them to any other case in this whole entire planet Earth that's ever happened. This is one of a kind. The people, the talent that we have, the knowledge, the Olivia, the Olivias, the Brandys, the Melanies. I mean, all of them, all of them. Yeah, everybody. Like the talent that has come forward just to help Karen. We're almost at $1 million. $1 million of $10, $5, $10, $50. We're almost at $1 million raised for that lady.
And I hope, I'm looking bigger picture. I'm hoping helping her helps everybody because the system is so screwed up. She happens to be the focus, but everybody paying that $5, $10 should be thinking this could be me.
I think you'll see more of Miss Reed in this maybe community type of a thing in the future because of how wrong and how much they tried to railroad her. And you know what the sad part is? They did this like it was yesterday. They did it like they've done it before. All too quick, all too easy. They know who to they know who to go to, knew who to send. So they've done this many times. So now we have to start going back and looking at all these other cases that just happened.
Wow. Speaking about donations, Mark Randazzo, we posted, Michael did an interview with him after the win. And then, as you know, he's been amazing with all of you guys.
Fabulous. What a great guy.
And he has asked, maybe we can put it into the chat. He has asked that if anyone can find it into their hearts, because he couldn't have done this without, and I know we're going to put the link into the chat. He couldn't have done this without the Liberty Center organization, and asked if anyone could find a heart even to donate $1 or $2 or whatever. So I believe that Missy's going to put that in the chat. And Randazzo asked that please anyone, because it's all of people like that and organizations like that help support you and Michael and now Erica and the 3 people whose winner. That's the Center for American Liberty. The Liberty Center, and there you go.
He is the best attorney in the country, and he comes and approaches
on First Amendment. On First Amendment.
On First Amendment. I mean, I wouldn't want anybody else. And he comes and he says, "Hey guys, you're getting screwed here. Let me see if I can help you." And he does.
Yeah.
Wow.
We were talking about that other agency that used to be helpful with civil liberties.
Long time ago.
Yeah, long time.
Yeah, I remember
ago.
that one. Yeah,
and really, the Center for American Liberty on a smaller scale, but growing, is kind of filling in that void. So, I mentioned when I did the interview with him, get a hold of Daytona. She handles some of the press and stuff for the office there in Phoenix, and she's very helpful. And if you want to get the word out about Center for American Liberty, they are very helpful in getting that done.
I'm gonna try and get that out there tomorrow on my stream, because without that, we don't get the help that we needed at that time that we needed it. I mean, Bev wins if he doesn't come forward. Bev wins.
Yeah, remember that the first case was the protesters case, which is technically the one that's been affected by the appeal, and the decision and the change in the order. We just kind of as parasite cases, so to speak, we benefit to some degree from that, although ours are not officially resolved yet. But it's because they looked at these cases separately. I thought it should have been the same judge. I know they're separate cases, but they gave them all to different judges. And I think that may have helped ultimately to get us where we are today. There he is.
There's a guy that's in there every single time.
Scott,
by the way, Linda, who has my name, okay, she's donated. Have a question in the chat, please address. Thanks. Okay, I'm looking back, Linda.
Well, you're looking for it.
Yeah, I got it. Here we are.
There it is.
Wait, is that one of them? Okay, is that one of them? You know, the best way to do is always put question before, because sometimes we don't see it. It goes by so fast when we're here.
That tells me it's a question.
Okay.
Does,
okay.
Does anyone
you're
know
smarter than me.
If Jen McCabe or any in her circle ever mentioned how terrible it was that John died in any of their emails? Oh, like sympathetic, like, my good friend John O'Keefe, I've not scoured all of their emails, but I don't know. Have anybody seen that pop up?
No, I don't remember it.
Any endearing references?
No, like the ones that said Karen's going to plead, and if she pleads out, that's the end of the ep or something like that. That group chat that said, "Oh my God, poor John O'Keefe."
She took care of all the mourning the next day at Proctor's house. She got it all out of her system when she ran in and went to the bathroom. She left it at Lank's house.
Oh yeah, that's right. But she didn't have a conversation with
that's right. 45 minutes in the parking lot.
I've had bathroom issues before. Hey, Scott,
have you really read over Beverly Cannone's decision?
Well, yeah, we've chatted about it, and I want to ask you, because I mentioned earlier that you would be throwing away your trash bag. You will no longer be covering your read time. Is that legit? Are you going to throw that away?
Well, I see. I'm actually jumping in here to say I disagree. I think Beverly Cannone's ruling on this is just word salad. She's just rewritten what she already wrote, just using different language.
Well, we talked about it, and I talked about it with Mark, and we went through it paragraph by paragraph, pros and cons, and I asked him, well, what's the practical effect here? And it's important to know the buffer zone's still in place. I'm now calling it the First Amendment zone, but it's still there. It's still there.
She didn't change the boundaries. It's still 400 feet on the church side.
It's just what you're allowed to do within it. And so I said, so what if some of the folks who were there last year want to get their ice chest, lawn chairs? He said, yeah, that's fine. They should be able to do that. When you guys were there last year,
you can't have any signage, no apparel. So we're just going to look like a bunch of people that decided to pull over on the side of the road and camp out.
I think you still can, because it has to, if it doesn't interfere. I'm looking at the fourth option here. Yeah, I'll just read it without putting it on the screen.
I'm trying to pull it up. I think he may be right.
Yeah, it says right here, the display of written or graphic materials that are intended to interfere with the administration of justice or are intended to influence any judge, juror, witness, or court officer in the discharge of their duties are prohibited within the First Amendment zone. Well, that's not your purpose. You're not trying to intimidate anybody.
But there's also another line where it says the buffer zone includes sidewalks and roadways that are used to access the court. If she doesn't move that 400-foot new buffer zone on the church end, I don't see how I can pull up to the old 200-foot line.
Oh, I would do it in a heartbeat.
And pull out my signage and wear this.
I think you can.
Yeah,
and Mark's think so? I don't know.
Interpretation is the same. Yeah. I told him this is going to be more dependent on the practical impact what the cops do, right? Because they're idiots. They have
that's
idea.
The other reason I wanted to call the show, because I just left court at 4:30, and Sergeant Mike Hardman was talking to several people down there that were going down to the front of the courthouse, and he's like, listen, we need to have a meeting or something, because He thinks that Beverly Cannone's decision's word salad also. He doesn't know how to interpret it.
Yeah, well, we knew they didn't know how to interpret it in the first place because they thought it gave them carte blanche to just start arresting people they didn't like or who were walking naked, basically, in front of, the zone. So I told Mark, I said, this is going to be a mess. I like that it sounds promising, but it's going to depend on how the cops interpret this. They can put any spin they want on an intention to interfere with something. You're intending to interfere. I'm standing here with my freaking sign. Well, that's good enough. You're intending to interfere. Okay, well then arrest
exactly.
me.
So who determines that? If I pull up to the old 200-foot zone, which is halfway down the church green there, that much closer to the court where we parked in trial 1, and if I, erect all my signs between the bed and cab of my truck, and I have my flag and I have my pre-Karen Reed gear on, and I get out of my truck and put up a couple pop-up chairs, am I threatening the court? Am I violating Massachusetts 13A, picketing a courthouse? Who decides that?
I think the order says you're not. Because I don't think that intending to influence anybody about anything. You're just expressing your opinion, kind of like First Amendment. Let me ask you this. This is a collateral issue. The area near the church where you guys had most of your hang area, right? That's their church property, right? In that public, that's private property for the church.
They even in trial 1, they had the church lawn caution taped off. We weren't putting chairs or tables or anything on the church lawn. We were on the public sidewalk. So
we're very conscious.
I think the church didn't like us out there, just like the current 200-foot zone that I've been using on the other end, just past the district court in front of that church. That's now dance studio or whatever.
Yoga.
They've been complaining all week that we're parked out there. And now they have the Dedham parking enforcement guy coming over and saying these are only 2-hour spots.
2-hour spots.
So we've been shuffling vehicles. They literally just don't want us down that other end because it's very congested. And I was saying before Cannone issued this ruling, just give us back what we had last year. But I'm very pessimistic of the way that Beverly Cannone wrote this. And I don't see it as a slam dunk win that everybody's celebrating today. I'm just reading it differently, but I'm not an attorney, and that's why I'm asking you guys.
No, I'm. It's a win in that it's a crack, in the armor. It's a chink in the armor. But I think it's written in a way that's going to cause as many problems as it solves. You notice in the 5th part of this paragraph, any person whose activity has been restricted by an officer enforcing this order may request review by a judge of the Superior Court, which request shall be heard as expeditiously as possible. I don't even know what that means.
That doesn't mean anything.
Well, it means you have a right to redress the issue, but are they going to get to it next August? I don't know what expeditiously means. I think that's a good provision, and Mark said they never even asked for that.
Can I have a dictionary, please?
Which one do you need? Theory?
No, I'll take the one that has theory in it, or has what was the word? I don't
orientation.
know.
Orientation. Yeah, right, that one.
Yeah.
And we forgot how bad Proctor actually was after today. We've all forgotten about how bad he is and how bad he hurt this case.
Well, besides Beverly Cannone's word salad, her rewriting of this buffer zone, I would have been just happy if she said, yep, we're going back to what you had in trial 1. It would be a lot more clear, a lot more understandable. The way she rewrote this, in some ways, if you read between the lines in some of this, it's actually opened it up to more interpretation. If I pull up to the old 200-foot line next to the church green and do what I want to do, decorate my truck with all my signs, be pacing the sidewalk up there with all this free Karen Reed gear on, who's to say that Sergeant Hardman or his men come up to me and say, hey, the buffer zone line is 200 feet that way. You're in the buffer zone. You're disturbing the court. You're influencing the jury. Who decides that?
Yeah, that's the question. That's the question I had. And it's going to be the cops on the street. And all hell's going to break loose when a handful of people get arrested. So if one stray person wanders in there, it's not going to be a big deal, and they really will have one. But if a dozen, 24 people get in there and do quietly, representing their voices, I think they're going to have a problem trying to turn that into a mass arrest scenario. I do.
And I was, Hardman doesn't know. You know, we were talking to him today. Jason went down there with a flag and a sign because, you know, he's one of the plaintiffs. And Hardman told him immediately he was across the street in front of the Registry of Deeds. And Hardman's like, no, you can't display the sign. You're okay standing here with your flag, which is a new thing. You couldn't even loiter in front of the court, even across the street before. So Hardman's compromised just an inch backwards that way. But I just feel that if we all show up tomorrow at a normal time at the old 200-foot buffer zone line and stop putting signs everywhere and walking around with free Karen Reed gear, I don't know how these police are going to interpret that.
Yeah, no, I agree, but it doesn't change the ruling and the interpretation that Mark Randazza has passed along to me, and I was very clear. I said, does that mean people can queue up right there at the stairs? And he said, yep, sure can.
I'm reading it the way you are because of the intent and because of the First Circuit opinion. Now, the question becomes, what does the Massachusetts State Police do to educate their people that they shouldn't be doing it? And usually what happens, like here in New York City, when they don't educate them and people get arrested, some 5 years later, everyone's $1 million richer for the violation of the civil rights. I mean, as long as you're not trying to interfere with the jurors and you want to hold peacefully protests, in my opinion, if I were there, I'd be holding up a sign, you know.
But it's not even a protest. It's supporting. It's not. We're not protesting. We're supporting Karen Reed. We're not. It's not
and you want to get there. You want to support the prosecution. You can do that too.
Exactly.
Knock yourself out. So I'm not giving you legal advice, of course, but I would have a copy of this supplemental order in my pocket. And I would have them show you where on there make them identify the area. Well, you're intending to interfere with the administration of justice. You know, get them on the record as to what they think they're doing, what they think you're doing that breaks this order. Because then what
is the distance that there's no. They didn't change the distance.
Doesn't matter. It's not a buffer zone anymore. It's a First Amendment zone. So the only area that she's carved out is the sidewalk. Second, prior orders remain in place as it applies to pathways, including public sidewalks and roads through which and at which time trial participants enter and exit. Well, that's a very small sliver right there in front of the courthouse.
The jury.
Not necessarily, because sometimes they park in the parking lot behind the Registry of Deeds. And they're coming up on either side of the Registry of Deeds to cross the street to get to the Superior Court. Sometimes they pull where Karen's SUV does on that one-way street. So how are we supposed to know when any of the witnesses are coming? What if they get dropped off down by the church and we're all on the sidewalk and they're walking through that way? I don't know which way.
Well, you could say that now. If you were outside the former buffer zone and you're down by the post office and somebody parks there, they're going to walk right past you.
Yes.
Right now, even as before this order was issued, it's the same situation. So somebody's going to have to find out what this means to the troopers. I think everybody from the court knows what it means. And yes, did she use waffle words, salad? Yes, no doubt about it. But use those against her. Don't be afraid of them. You know,
this is
the First Amendment, man.
Yeah. Here, Gerard O'Suave, a donation. For information, Harmeet Dilan, the DOJ Assistant Attorney General for Civil Rights, reposted a Turtle Boy post about the buffer zone update. This is huge that the DOJ AAG is watching job. Well done by Mr. Mark Randazzo.
I
think that's absolutely right. Absolutely,
and she is amazing.
So
she is an amazing attorney. Had a huge practice before they brought her into the dark side, better known as the government. If she's latched onto this, that's giving you
that's some credibility, and I think that you guys.
I'm just saying, because of what I heard from Sergeant Hardman at the end of the court day today, and his not confusion, but not really realizing like how they're going to enforce this. I'm not comfortable tomorrow to just
I think
pull up
unless
to
you-
the
yeah,
old
do it.
200-foot line and do what
Yeah,
I
but
did in trial
what if
one.
you don't? What if you don't? If you don't, they're going to say, "Hey, you know, we
You
won.
win.
Well, you win."
There's no
Yeah.
doubt. But I would never put that on anybody. If you don't want to do it, don't do it.
No, absolutely. Don't get yourself arrested just to be a
Yeah.
martyr.
Yeah,
Yeah.
I'm just saying that I think the weapon is now in the hands of those who want to use it.
Right.
But this is huge. This is absolutely huge. If this is huge, if she reposted a Turtle Boy post about the buffer zone, and remember, Turtle Boy said this is a big win. We actually reposted his. Okay, that's really huge. That sends a message.
No,
And somebody from
Yeah.
the Massachusetts Attorney General's office better get on the hand of the Massachusetts State Police and say, "Hey, look, okay," because Judge Cannone just didn't write that order. It had to be reviewed by attorneys, right?
Right.
Had to
Yeah.
be reviewed by so that people are watching here, and I think that is absolutely enormous. Thank you, Gerard Oswald.
Yeah, super helpful.
So much.
Like
Very,
tomorrow
very
morning, right? I'm gonna go up. I'm gonna wear my tie. No Karen Reed stuff. No Turtle Boy stuff. I'm gonna go and wear my tie and use my camera and do my job. That's all I want to do in front of the courthouse. That's all we've all been doing is just supporting Karen. They're making rules that are complicating this where it doesn't need to be complicated. We can do the outside stuff. The people on the outside got it covered. Trust me. They can manage the cops.
Well, part of this, and Scott, you're right. I mean, the judge is trying to cover her ass and save face because she's been slapped down, right, by the federal courts. She's been told you screwed this up, and they're giving her a chance to fix it. I am confident they'll be happy to take a look at this if people start getting arrested and there are emergency motions filed because she didn't fix it as she was told to do. So it's going to happen. I wish I were going there tomorrow, but I gotta be somewhere else. But I'd love to be there tomorrow to capture what's going to happen, and something has to happen. You can't just go, oh well, this doesn't really help us. Okay, we lost. It's a big win. It's a huge weapon, but somebody's got to use it.
Yeah, I get what you're saying, Michael, but I'm just saying the way Beverly wrote this and the feeling I was getting from the police today, boots on the ground, just as I left court, which ended a little late.
No argument.
They're clueless. I don't know. I don't have no idea what to expect tomorrow.
No argument.
Scott's right. Hartman, he's the guy with the handcuffs and the gun. So
Yep,
he's the guy can lock you up. So
if
he's not informed, Scott's right. If he's not informed, that you get 30 orders, it's not going to help him. Not going to help us.
Well, it's going to take somebody doing something to test the theory, to test the waters. Erica, she offered to be arrested, and they declined that opportunity, right?
And then there's something in this order where you have a right to a hearing in front of a Superior Court judge.
Yeah, I mentioned that.
So does that mean they're not going to arrest you and you're going to get a hearing date?
No, it says any person whose activity has been restricted. Now that could be just don't come in here, we're going to give you a ticket.
Right.
That could be arrest. That could be anything that prevents you from doing what you want to do. Anything.
So say I go back to the old 200-foot line in front of the church green. I adorn my truck with all my signage like I did in trial one. I get out with all my Free Karen Reed apparel on and my Free Karen Reed sign. And Trooper Hartman or one of his men marches down to me. Is that my warning? And then if I refuse to leave or change my activity, then they can arrest me?
Well, I think at that point, if somebody says you have to leave, okay, I think then the qualification for the 5th paragraph kicks in. Any activity restricted by an officer. Well, if you're told to leave, that's it. It kicks in, and you can now ask for a review by the judge.
Yeah, but you walk out. You get walk out. Don't get yourself arrested. They walk out, and then you
and then file, and they get they get a blizzard of 100, 150 of these complaints.
Yeah, that makes sense. So in the scenario I'm imagining, I go to the old 200-foot line in front of the church green, do my thing. They come over, they tell me, oh, you're still within the 400-foot buffer zone. You're in violation. You have to leave. And then I could motion to get that hearing in front of a Superior Court judge.
Yep, you have to. Let's see how they phrase it here. You may request review. I'm going to look into that and see what does that mean? Is there a piece of paper you have to file? Is there you just call them on the phone? I mean, what is that process to request review?
That's what I mean by the ambiguous toss
Well, she's
salad
not going to make it
language.
easy. She's not going to say like, attached, please find the form you'll need to fill out to request review. No. And again, I'm not giving you advice. What I would do is have that order with me and say, Trooper, I hear you. Tell me here what I'm violating. So when I request review, make them aware. I would make them aware when I request review, I want to know exactly what you think I've done wrong. You know, I just don't think they'll be able to survive a tsunami of that kind of response.
Yeah, and make sure it's filmed though. Somebody's filming that. If you do
Yes.
it.
Yeah, and then if I request review in front of a Superior Court judge and it's scheduled for September,
well, that's
long after the trial's over.
Yeah, but you're that's another issue. But that's
yes, it
yeah,
says
right now it's a big win.
expeditiously as possible. They could very easily claim we're clogged up. Courts are clogged up. These are all of that type of information is what would be necessary for another action against them. So, you know,
well, Mark Randazza has already alluded to the fact that he might have to further pursue this already. I was hearing that boots on the ground today.
Well, I interviewed him today, and that's you know, we talked about it. You know, he just like anybody else can only look at it on its face and say, here's what it should allow. Let's see what happens.
Yeah. By the way, Joey Kane just gifted another Justice Served TV membership. If you haven't seen Joey's work, he created Mr. Fluffernutter for me. That's Natal and Fermenti. And they're eating, one of them is eating a Fluffernutter sandwich. All right, so can we get into a little bit of what happened today? Because we're going at the end. Linda, if we're okay. I may have been mistaken, but honestly, it seems to me the defense is setting up the prosecution and getting into the evidence, all the things they are going to hammer them once they present their defense. Can we talk a little bit about today's proceeding, because it started off this morning. I know Michael wants to talk about it, about something we have never seen in court, which is Maureen Hartnett, the crime scene analyst, who sua sponte, meaning on her own, after she finished testifying, got off the stand and said, Michael Bryan?
Oh, you want me to finish? I was looking for the video. Yeah. Could I correct something that I said yesterday? I didn't know the right time to bring it up.
Because no one's going to believe this.
Of course, I don't have it queued up. I got it here somewhere, but it's definitely not queued up.
So I know both you, Scott, and you and Tommy, you both were watching the trial. I mean, we're going to talk about the end, about the prosecution again trying to sandbag. They try to sandbag their own medical examiner. They try to sandbag the defense this afternoon. And the question is Judge Cannone going to allow them? Okay, that's a question that, you know, when I started this case, I was very open to saying, no, she's going to be fair. I'm not so sure now, okay? But, you know, actually, I'm very sure now. But,
yeah, I would think so. See, we got a lot of bodies here, so I'm sorry if I've smushed somebody out. Oh, that's better.
That's the medical examiner. That's Dr. Irini Scortivell.
Okay, just I know who I'm looking for here. I just I was testing it earlier.
And Joey Kane gifted another one and another one. Another thank you, Joey.
Shocked about that, Joey.
Your absolute
He's great
support. Absolutely great.
He's a great guy. Yeah.
Great, terrific.
What was the mistake she was trying to correct?
We'll never know.
I don't know, except it was an answer to a question of Mr. Alessi, or as he's been now named, the Alessinator.
And the judge said, "No, get out of here. You're not."
Well, I think that was probably best for everybody, but it was a weird moment. It was just weird.
That was weird. I forgot about that curiosity moment today.
Yeah. I started this morning with a rant about her that we've also posted on Justice Served TV. We cut out about her from yesterday.
There's so much wrong with this case.
Let me see if this is close to. Let me see if this is close.
Oh.
No, this is when this was after they ruled. Like, what was it? Judge C says to everybody, "You're all set." Okay, you're all set. That's what she tells the witnesses.
Yeah, that's what she usually does. Yeah.
You're all set.
Were pulled from those clothing and placed in the taillight area. Would you know when they were placed?
Objection, Your Honor.
Sustained.
When you get to a scene and you examine an area, if you don't see it firsthand, is there any way you can date when items are placed on an object?
I'm sorry, can you ask that one more time, please?
When you look at an area like a taillight, if you found blood,
you're torturing me by playing
or another item in that area, would you know, like, if you found?
I'm sorry, what was that?
You're torturing me by playing Hank.
And you know, Hank at 1.5 speed.
He had a lot of trouble, by the way, though, on her redirect. I mean, a lot of trouble on her redirect. A lot of, you know, he was struggling today. He struggled.
Yeah, this is as anybody knows. I've got a 7-hour clip here, So pulling it to that 1 minute we need can be a little tricky. Yep, see, there she goes. So somewhere between those two points in time,
yeah,
somewhere in those 2 points of time, we have her begging to correct herself.
Before the sidebar, before this.
Is this the right sidebar? That might have been the sidebar where they were talking about it.
Yeah, maybe.
Yeah, it's just it's a because she's talking about evidence here, which is not.
Do you recall which lawyer asked you the question? Yes, Mr. Leslie asked me the question.
Oh, wait, hold it. That was the secondary part of it. So let me see where I am. I'm at a minute. I'm at an hour 10:20. Hold on. Let's see this. This is where she first says she has to correct something, and then the judge asks who she was being, questioned by. She says Alessi. Alessi says, "Your Honor, are we going to continue with this?" And then they have the break. So, come on.
We're counting on you, Michael.
Yeah,
Linda, I got a question for you in the meantime.
Yeah, go ahead.
Compare the Karen Reed trial and how wrong it is so far. Compare it to something else we've all witnessed in the past. What's the closest you can get to it?
Well, you may not have witnessed it, but we as defense attorneys find this all the time. Okay, we get hassled by judges. We get wrong rulings all the time. This was bringing it to light, because no one believes us when we say they say, "Oh, you terrible defense attorneys! Look who you're representing." But this happens all the time in courts around the nation. It just happens right this time in front of you all with really good attorneys and a lot of interest. So I'm very happy because I think people have been railroaded for too long on the viewpoint that, oh, you're those slimy defense attorneys. And that's what Hank Brennan tried to do here, right? That's what he's trying to do here for the people, those slimy defense attorneys, right? So
he's the slime ball. He's out sliming anybody.
He's a defense attorney.
That's true. Okay, this I think is as close as I can.
Please?
Sure. You didn't
so bear with me
do any analysis of what could have caused that hole in the sweatshirt, did you?
No, I did not.
No further questions. Again, thank you for answering my question.
Your Honor, you are all set. I wanted to correct something from the record yesterday. I wasn't sure when it was appropriate to do that.
Okay. Do you recall which lawyer asked you the question?
Yes, Mr. Leslie asked me the question.
Your Honor, are we going to proceed along with that?
So why don't I see you a second?
Like,
Pam has no idea what to do with that one, does she?
Your Honor, are you out of your fucking mind? I mean, are we gonna continue with this?
That's exactly what he said. In so many words, Your Honor.
Did she catch her own mistake, or did Brennan tell her she made a mistake yesterday?
Well, the judge was like, "Okay, who asked you? I mean, what are you talking about? Who asked you?" Okay. Anyway,
I don't think I've ever seen that in a courtroom.
That I haven't seen. I have to say, I've never seen a
that's all we
witness
have from
after
that
they finish
witness.
testifying.
You want to look at the
saying that they're going to correct. They want to correct their own.
when she was getting redirected and Brennan was having such trouble.
I'd like to see some of Alessi when she says that this was not an impact strike. With the old medical center, it was a surprise to everybody. But I thought, as we said today, that we think that he decided he had to call her for a number of reasons. One, he was taking a lot of heat on the internet.
Talk amongst yourself, people.
How does he get his own doctor, as I call him, Dr. Gamma Ray surgeon, unless he has the predicate testimony from the medical examiner, Dr. Irina Scortivella? I think he just felt he could.
Were you guys surprised that she testified based on your research?
I'm surprised that Brennan called her. I thought the prosecution was going to skip her and the defense was going to have to call her.
She never mentioned how much, like, the clothing would affect how much somebody loses the temperature in their body, because your clothes and how you're bundled up would dictate how your body loses temperature in the cold. Yes, she never calculated that in her thing, or did she?
She never did. She sort of tried, but she never quite came to an answer.
So
I was joking in one of the chats. While
we're doing that, we do have a question. Question Tom Barnes: what does Linda Michael think about Alessi's genius getting Commonwealth ME to discredit future Commonwealth witnesses, neurologist Judd Welter and/or Dr. Zeke Wolf? It is. I forget the name. It's Dr. Zeke Wolf. It is. And I thought, I said this morning, I think, Tom, that was brilliant. I did not see that coming. Okay. I honestly didn't. I don't think anybody saw that coming except for Alessi when he went through the whole idea, the whole system of medical legal investigations and why it's set up and how it's set up and people having board certifications for forensic pathology and the whole system. And then, he gets about opining about cause of death and manner of death. And then he gets to, he's trying to then talk about the forensic neuropathologist for the state that the state's not going to call. That would also help. He gets cut off at the knees there by Judge Cannone, but then he just asked Dr. Scortivella one question, and sometimes one question is all you need. Have you ever heard of Dr. Zeke Wolf? Okay, and she says no. Okay, and I thought it was brilliant. I thought absolutely brilliant. I thought Alessi only had one misstep, which we can discuss later today, but I thought that was absolutely brilliant. Tom.
Yeah, I mean, to basically head off the pass, the expert that is coming for the prosecution, and have your own expert say, well, that person's not qualified. The person's not able to render any opinion when that person pops along. That's what we're deciding. What's the question going to be to this other witness? Are you aware that so-and-so believes you're not qualified to give an opinion on death? Objection. That's all right.
Yeah. Are you aware that you're not even, you couldn't even sign a death certificate for John O'Keefe? You didn't treat him, right? You're not a medical examiner here. You're not even licensed by the state of Massachusetts, and you're coming here to try to undo the opinion of the state's medical examiner who testified before this court. I mean, I just think he's so
I think Rini Scortivella was all over the map herself. I mean, John O'Keefe could have died 1,001 ways. She can't pick one.
Yeah, she was definitely maybe.
Well, she did. She picked blunt force
for
trauma.
what she got.
I think actually she was very good. She picked blunt force trauma. She held her own. She said, "Look, because what it was is that with Hank Brennan, he was trying to get her to talk about the hypothermia, and she said, "Look, I can't say that he died of hypothermia. It's a contributing factor, but if I didn't have I have a cause of that blunt force trauma, so that's contributing. I couldn't say without the blunt force trauma he died of hypothermia." She said that, and I actually put in there star nail in Hank Brennan's coffin there, because I thought that was actually more important. It was equally as important as the fact that she said there was no impact. This was not an impact by a car, okay, type of death. But that is another.
That was the killer. That was the killer,
right? And obviously, when the defense calls witnesses, that's going to be highly backed up by ACA.
Of course, but this is the Commonwealth's expert, and to have her say, "I saw no evidence of an impact with the vehicle."
Well, the bottom line comes down to this: that the way we're getting the data from Karen's team and from Hank, because Lally was terrible at giving us data. Well, we have data now, and Karen's team has data. It's how do we take that and get it to the jury so the jury can make a decision of not guilty? Because that's what it comes down to, them people in that box. I mean, last year when I heard that they just dismissed the fact that there was a dog missing, like the guy's arms chewed up, and you're going to dismiss a dog out of the equation? That blew my mind. So the jury kind of scares me. That's why I'm really kind of thinking what they're giving us for data needs to get to the jury so that they can comprehend it the correct way.
I think all juries are scary myself.
Yep.
Yeah, and and Cannone adds to that when she won't let the jury know that the federal forensic pathologists or pathologists and ARCA were hired by the Department of Justice, which carries weight and is important in and of itself. I mean, I think
but that obviously sinks the state's case. That's why Bev's preventing the jury from knowing that. So.
Yeah. Obviously, I mean, jury selection may not have been one of the high points by keeping a cop on the jury so that the judge could make him the foreperson. And also there was another juror who's been making the rounds who, quite frankly, I'm like amazed about. But you're absolutely right. You're absolutely right, Tom. You never know what a jury is going to do. I've said this to people. Look, people can say, look, I'm just going to take the easy way out here. There was glass. She was drunk. Blah, blah, blah. She, she just nicked him. She didn't know. She didn't mean to kill him. And therefore, goodbye. I find her guilty. And someone said that to me, just find her guilty. I said, no, look at all this other stuff.
Well, I mean, look at the first jury. We had what appears to be a influential foreman that was putting the seed of thought into the minds of the other jurors. Like, hey, this razzle-dazzle defense, ACA they're all distractors. Don't believe these fancy smancy lawyers. They're like too good to be true. And
that's what I say. Yeah, to fancy
you know what I mean?
We're always fancy, miserable defense lawyers, slimy defense lawyers, always trying to pull the wool over your eyes. And that's, we thought that was changing a little bit with the Young Thug and with ASAP Rocky and with Alec Baldwin's case, but no, it's still out there, and people believe that. People believe that.
Well, it's hard to deny it now. And every single piece of the evidence in the Kieran Reed trials, there's something wrong with it. Every single piece of evidence, everything.
Yeah.
How'd you like the box? How'd you like the box that had all this stuff in it?
The box. What's in the box? But we've seen that with the chain of custody, lack of chain of custody with virtually everything. It's all been commingled and poorly collected and poorly stored.
They're so uptight about a freaking buffer zone that they let somebody put a rock at the crime scene that says Albert on it, and the next day it's gone. It just disappears, and the judge is okay with that. It's come out of heaven, and then it's gone.
Well, I mean, to be fair to Bev, she did address the jury the next day, didn't she? And said, "Hey, juries, ignore the rock that was planted in the yard." Didn't she do that?
Yeah, she did.
There were 3 state police out front of that house watching that vehicle.
Yeah.
I mean, everybody brought it up today with Scotty Bello.
They can't go find out who put the rock. They can do 65-page report on rubber ducks. They can't find out who put a rock there painted with their name on it.
Oh, there's no, because the cameras aren't from the chief of police aren't pointed there, or the
deputy chief across the street can see it.
Right,
yeah,
right. They're not pointed. Linda says, and because her name is Linda, of course, $5. Without me, it's a different Linda. The Nation, watching this case for the first time, Proctor tainted this case from the start. As a juror, that would be reasonable doubt. Case over. But that's what we need, Linda. You need somebody in that jury room when they get hung up on like, did the defense prove this? Because defense has no burden to get up there and stand up and say, hey, our job as jurors, remember, is to find out whether the state proved their case beyond a reasonable doubt. If they did not, we go home.
Yeah, exactly.
Fruit in the poisonous tree does not apply here.
Yeah, it is dangerous, though, because when even the witnesses the prosecution puts on sounds like they're defense witnesses, it's not a bizarre move for, an unschooled juror to say, well, here's the story I'm being told. I don't hear it, but they're thinking about the defense story instead of the prosecution story. There's still huge holes in the prosecution story. There's been much more evidence of the defense theory of this case. And that's where I think the last jury got kind of sidetracked and started thinking, well,
no, exactly. They were pursuing the Karen Reed was framed third-party culprit thing.
And they think, well,
so then the jurors are like, did the defense prove their case beyond a reasonable doubt instead of the other way around?
Of course. And so we know that they, on the opening, leaned less heavily on the whole framed thing, but they did throw out all the facts that would make you wonder, what the hell's going on here? What was being done? But I think they backed off on the framed thing, and I know they're going to pound hard on. We don't have to prove a thing to you folks. So all of this stuff that we've put out there, don't hold us to a standard that doesn't exist. They're the ones you have to hold to a standard. They're the ones that have to prove to you before you even get to what we've talked about. They have to prove to you beyond a reasonable doubt that there's some guilt here. So,
I think that's where juries go off track, because they want to leave that courthouse thinking they've rendered justice. No, I think a juror should go into a jury box very pessimistic of the state. That my peer is in the defense chair, and the state has to prove to me beyond a reasonable doubt that they are guilty of this crime. So I would, if I was ever allowed to be a juror, I would be very like, prove it to me, state, because I don't trust you.
By the way, Scott points out, I love that Alessi called that hang for burden shift. And as a matter of fact, he did that after Alan Jackson came over to him, if you notice on the thing. And Alan Jackson, we tried our case here, your burden shifting. You should tell them with this whole idea of changing your report now. It's just ridiculous. It's ridiculous. It is so ridiculous.
They're lucky they got a report. Some people touched the truck, they never wrote a report. There's reports that haven't even been written yet. 500 days later, report.
Oh, what about former Officer Wanless that worked for Canton PD that removed the taillight housing? He's nowhere in the chain of custody. They kept his identity secret.
Yep.
Well, all of this Rule 14 stuff, it's like Brennan has the best memory ever because it's very selective. He doesn't remember all the outrage he had when he tried to, get stuff from the defense, and he was just, and he mentions it again today to the court. I know the court's already found intentional issues with the defense, so he tries to piggyback on that. Therefore, since the court found that they have done something wrong, whether you believe it or not, the fact the court found something twice. Now let's bring that here to help us in a situation in which we're trying to do what we've been accused of doing in the past. Yeah, you could, but the thing is, the wild card here is Judge C. You don't know what she's going to do with this. No idea.
Yeah, and then you got Brennan going after Acker at the very end of the day again. I thought Acker was all set in stone, and now he's going after Acker again.
He can't win. The Acker is his white whale that he just can't beat.
Oh yeah, yeah. But it's like early on. I don't mind if Acker testifies, and all he does is try to get him out of the trial. Yeah. Crazy.
Mara points out that she's been on a jury selected our appointment, but some defer to the foreperson. And in Massachusetts, it's one of the few states that the judge picks the foreperson. And, we objected to that, obviously, in Hernandez. We said that's unconstitutional because it can be biased in favor of, the judge picking somebody who is not of color, since that's what happened in Hernandez. The only white person was the foreperson of the jury,
But
who do you think the judge is going to pick? Someone who she thinks is prosecution oriented. That's who judges pick. I mean, that's the system. Teresa.
We were told in Massachusetts, and what I've observed is most judges just pick juror number one, whoever it happens to be. There's no consideration.
Well, that's okay. I mean, that's the way it is in New Jersey. Juror number one is always a foreperson, so there's no consideration. But that's not but that wasn't the case in our situation. That's for sure. And so, not the last trial, right? Was he foreperson number one? The juror who was he number one? Do you remember?
No. Was he physically number one?
I don't remember his number. If he had
a
number.
That's what I was told.
It was okay.
But if you put your tinfoil hat on, how did he end up in seat one? If it was a planted form.
And then we have Lieutenant Fanning from the state police, who quote is overseeing the jury, who's babysitting the jury, in charge of the security of the jury. Like, we don't know that he didn't read the jurors' notebooks, and they threw 3 jurors off the jury last year because they were pro Karen Reed
just before deliberating. I mean, that's shaky.
Exactly.
That.
So does that shock you now? When me and Scott are out there screaming, "This is wrong! This is wrong!" Now the whole world is watching, and this whole thing's falling apart in front of them. Everything is wrong. I'm glad it's about time everyone else is seeing what we've been screaming for 2 years now.
Yeah.
Well, just like in trial one,
Linda's hearing you. She says, "I have faith she will win this trial."
Yeah. Well,
just like in trial one, this jury is bussed in from a secret location, and we don't go behind the court. We don't ever try to expose ourselves to the jury.
No.
So I have no idea what state police unit is escorting the jury this time in trial 2. Hopefully, it's not Fanning and his guys.
Yep.
Well, the defense is on it. That they know everything, right?
Yep.
Sylvia Jerome, the jury foreperson is chosen by the court. The court has in the court rule statute, which has to be changed, but it hasn't been changed all these years. There's no indicia of how the what the parameters are and how the court is allowed to pick the jury. Just that the court is allowed to pick the jury foreperson.
Right. And I think maybe over history, tradition, judges in Massachusetts just pick juror number one, whoever that happens to be.
Teresa, I thought we answered, by the way. Teresa says, I thought we answered your question. I thought we did answer your question, Teresa.
I'm looking again.
This is one. Brennan, is asked her to change. Okay, I'm sorry. Asked her to change her decision. Why didn't Leslie bring up Proctor? I would put it up. And he actually did. But see, what he couldn't do is we know the bullying is because of the text message about she's a whack job, right? But she didn't know that. All she knows is she met with them, and they presented her the theory of the case, okay? And she wouldn't change it. She wouldn't change it. All right. So so that was gone into. But the whack job, do you guys remember? Was the whack job a quote or a text read by Yuri Buchanan when he was on the stand?
Proctor read it on the stand.
Yeah.
I think
was
Proctor
Proctor.
read his own text.
Yeah.
Yeah, he
Trial
must
Yeah,
have.
yeah, but not in
remember-
this trial because Proctor wasn't here.
Well, there
so
were
we
two
made it
different
Right.
groups. There were two different groups. You know, we had his buddy group, and then we had the couple of cop groups. So they only read a few of them.
Proctor hasn't testified. So did Buchanan, when he read the four, did he read the
Right.
she's a whack job, or was that out of the presence of the jury? Do you remember?
He did not read it. He did not read that
Yeah,
one.
yeah.
No.
I don't think he read it last year. He did, but he didn't.
He
this
read
year.
the messages between Karen and Higgins.
Yeah, see, that's why it
Okay.
was very specific. Buchanan couldn't read those that he wasn't part of the chain. Remember who was on the chain? Buchanan was on the chain. Fanning was on the chain, and Fanning was Buchanan's boss, right?
Tully.
And Tully.
Tully was his boss.
But then the other text that Proctor read, most painful, were the ones to his cronies, not necessarily his bosses or
His high school
coworkers.
friends. Yeah.
Yeah.
Well, that's why Yuri Buchanan was on the stand for so many days. They were trying to use him as a vessel
Sure.
to get to like the Higgins texts and the
Couldn't get past
Proctor
what
stuff.
theory was. Yeah.
The Chico, correct. The Chico was there.
Yeah. And that's the only reason they got him in through him, because he was on the chain.
Yeah. I got a no says donation, call Dedham police number and get clarification. They're not going to tell you. And plus it's the state police that have really been doing the dirty work. Dedham actually had a press release the first day that it was out that said, look, public sidewalks will remain public, and if we close them, we will let you know. Their actually release was pretty darn good. And then the Massachusetts State Police, we were on the air with Michael and you, Tom, and that's what we were actually airing live what happened to you both and all. And Scott too, you were there too. That was the whole thing. They were walking you, right? You were all walking together. That's how we got to know you. That's how I got to know you guys. I mean, Michael knew you guys because he was up there. So Dedham is not going to help because they're not going to go against the state police. And then Linda again says, by the way, faith and prayer are so powerful. Never get up. Give up. These guys are not giving up. They're putting their reputations, their life, their time, and everything on the line. Tom and Scott, and it's just a pleasure to know them, to have that kind of commitment to truth, justice, and I won't say the American way, but truth, justice, and the justice system as it should be. So.
Well, there's one quick thing I wanted to ask you. So they've been doing a lot of interviews of, man on the street, Vinny Politan from Court
Vinny
TV.
was up there. Yep.
CBS 4 Boston asked me a question the other day. What do you think? Is the prosecution going to call Higgins or Proctor or not? And if the defense is going to call them, and what's going to go down? And what I told them was, I'm worried that if the prosecution doesn't call Higgins and Proctor, now the defense is calling them, they can't just run out there and like impeach them unless Bev declares them a hostile witness. Is that correct?
That's correct. And I don't think they're going to call him for that reason. And also, not only that, Hanky can also try to rehabilitate them because he can ask them all sorts of leading questions on cross. So I don't think the defense is going to call either of them if the prosecution doesn't. That's my opinion.
Yep.
Right. And that's why I think they were using Yuri Buchanan to bring out some of the texts, Higgins and Proctor stuff, because Higgins and Proctor may never see the stand in this trial.
Well, go back and look at the opening by Alan Jackson and tell me they're not going to call one or both of these guys.
Yeah.
They haven't gotten to some of the stuff they promised in the opening if they don't. So
Michael thinks they do. You think they're going to call Proctor, right?
Because
Michael?
of his opening. Because of the opening.
He's too pivotal. He's so bad. You can't not call him.
I don't see Alan Jackson throwing out things that are specifically going to come in only through Proctor if he's not going to get them from Proctor.
And they've been throwing Proctor's name out there every chance they get.
Oh yeah, and I get that.
Proctor and
I get that, and that makes perfect sense whether they called it or not. But I just go back to the opening and tell me that you think they can get in what they suggest without Proctor. I don't think they can.
I'm just worried at the minute the defense calls Proctor to the stand, and the defense starts going to impeach and whatever. Bev's going to refuse to declare him a hostile witness, and then you're in a pickle.
I agree with you. I'm with Scott. I agree with you, because he's going to sit there and say, "I'm so sorry. These were not professional. I didn't."
Yeah, that's definitely what he's going to say.
I think 9:30 tomorrow morning, Bev calls mistrial. That Rule 14 stuff is so big and so bad. They're halfway through the witnesses, and they got to start over because everything that they've done their research and everything's based upon wrong time.
Yeah, I don't think that's happening. I don't think that's happening.
That's a shame. That is a shame. That's
I
what the
want
world
more
is looking at. Yo, we're gonna get him, I think.
Yeah, he's horrible. He's back to his home country, I'm sure, looking for a new job. So, so what's the plan in the morning, guys? Tom, you're going to be out there your normal
early there
position. Your where do you normally go before 8 o'clock?
Down by the post office, what Scott was
Okay.
talking about with the what's it, the dance studio?
Yeah, and
yeah,
by
down
the post
there,
office,
that side. Yeah.
Okay, that's at 8 o'clock. You go there, right?
Yes.
But before that, aren't you in the First Amendment zone?
I try and get there by 8. So
Okay.
Yeah,
if I'm in there
I
earlier,
get there. I get there earlier than Tom. We're in front of the courthouse 7 to 8 a.m.
Okay.
where the buffer zone is not applied yet.
Okay.
And we do like a prayer, and then we march up to the other end at 8 o'clock.
Okay. So you voluntarily, has that ever been something where they've ushered you out, or you just voluntarily done it?
No, even Sergeant Hardman, he's like, you guys are good till 8 o'clock. The buffer zone doesn't start till 8 a.m. So if you're in front of the court 7 to 8 a.m., I can have my free Karen Reed stuff, my sign, everything.
Yeah.
But at 8 a.m. we turn into pumpkins, and we have to go up to the 400-foot line, because that's where Karen Reed drives in.
Right.
And then you've been with me. Then I bag my sign, and I go 600 feet to the other 200-foot line. That's been my normal routine in this trial.
Yeah, that's why I just wondered if they were reminding you of that before before you actually went voluntarily.
But tomorrow morning,
we just know it's 8 o'clock.
Yeah,
we have to go, otherwise Hardman's going to come across the street and tell us to get away from the front of the courthouse.
Yeah.
So they're proactive already. They're already following the rules that are wrong. Like they're wrong rules, but they're still following them because that's what's put out by the guys with the guns and the badges, and they all comply with it. No one sits there and complains about it. They just do it, So tomorrow morning, hopefully, they don't have to take a walk. If they can stay right where they're at.
Well, I mean, like I said earlier in this show, like this interpretation of what this new Bev ruling is, I guess in theory, tomorrow morning, I could pull up to the old 200-foot buffer zone line on the other end in front of the church green and just see what happens. Apparently, I get one strike. If they tell me that if I've been ordered by an officer that I'm in violation of the buffer zone, then I can vacate that area, and then I can apply for a hearing in front of a judge. That's what I'm getting out of it.
Yep, that's it. Once you
Dedham
interpret something they've done as a request to leave or suggest that you're violating the order, that's when you can make your request. And I would, again, I'm not telling you, I would make it clear that's your plan. Okay, well, I understand, because you're going to have a copy of this. I mean, I would have a copy of this. You say, well, look, I can request review. So let me have your name, if you don't know it, badge number. Tell me where here on this order I'm in violation, because I need that for the hearing I'm going to request. And you'll be present at the hearing. You need to make sure you're there. Yeah, it's going to be, somebody's going to have to test that, or a few people are going to have to test.
And again, we can have 50 pieces of paper all saying different stuff. If Hardman doesn't know and he's not educated, it doesn't matter, because unfortunately what he says goes, because he's the judge outside.
Yeah, no, I get it. I get it.
I don't even think the police.
So then your lawyer is going to file another emergency motion. That's what's going to happen.
And I don't even think the police are comfortable with this, because Hardman didn't sound too confident as how he's going to interpret this. I think the police would rather have a much more clearly defined rule.
Absolutely. Yep.
Yeah, it's really not fair
wide
to
open.
them.
So now they're leaving it up to the state police to determine whether or not, if I'm at the 200-foot line in front of the church green, it's up to the police to determine whether or not I'm violating the buffer zone. Because what if I'm just standing there silently holding a Karen Reed sign? Is that,
well, that's
or it's just holding the sign so offensive and it's only 200 feet from the court that I am disrupting the court?
Well,
like,
how is that? They have to make the argument, whether it's in your face at the time or in court later, that you are interfering somehow with the process. Good luck with that argument. A person standing with a sign 200 feet away.
That's what started this. That's what started this. That's the case.
Yeah.
That's the case. That's the
And
case.
we're back to where we started.
So let me read this again.
Linda, by the way, again, 200, before you read it, another $2. Tom and Scott love coming your way. Obviously, they love you here. They love you.
Thank you much. Thank you.
Quiet off-site demonstrations on public property. Okay, that's the first part of the phrase. Quiet off-site demonstrations. The site, although not as clearly defined in here as I'd like, is the courthouse area.
Exactly the problem.
Yeah.
What is off-site? That's what I don't understand.
Off-site, is that what's
outside the current buffer zone perimeter?
Yeah, well, that's not a reasonable interpretation, I
And-
don't think.
and
I
they're
would
not
argue that it's the courthouse, outside the courthouse.
They're not protesters, they're supporters. There's a difference.
But they even allow demonstrators there. That order says demonstrators.
It says demonstration, off-site demonstrations on public property.
But they're not even doing that.
But I want to know what off-site is. That's what I'm confused about.
This helps a little bit, but not entirely. In areas and at times that do not interfere with trial participants' entrance. Well, it's not
That's
like
easy.
They don't
The
have
jurors
every
come in the
place
back
covered.
door.
Well, see what's unique about the Dedham courthouse areas. So you have Dedham Superior Court, you have the Registry of Deeds across the street, and then next to that is Dedham District Court. So I think Beverly and the parking lot behind the Registry of Deeds, I think Bev considers that all one big court property because the normal jurors that aren't bust in secretly to the back door, the normal jury pool is in the Registry of Deeds and they walk across the street.
Right.
So I think Bev is considering courthouse property to be all three of those properties, including the parking lot behind the Registry of Deeds, because that's where potential juror pool people park. She's looking at it as one big three property area that she considers her, state, grounds, court grounds.
What could happen with a less specific order like this, which is full of those questions more than answers, is it's gonna be voided because it's vague and ambiguous, and it's gonna have to be done again, but only if somebody challenges it. If somebody lets it go and follows what they think this rule's against, then nothing will happen.
What about
Tom and Mike? You know this. You know the landscape. If you're standing at the Superior Court steps, looking at the Registry of Deeds, you can go around the left of the building to get to the parking lot.
Yep.
And I've seen witnesses come up that sidewalk and then across to the courthouse, or they can come up on the other side of the Registry of Deeds. So anybody near there is in violation of the buffer zone. You know what I'm saying? That's right.
I do, and I'm not disagreeing that it's vague and ambiguous. I'm just saying if everybody just cowers and retreats to wherever they've been, then this means nothing. It means nothing.
This is a win. Remember, we got the Attorney General, the Civil Rights Attorney General. Let me just go for a specific question of what we're talking about. Daniel Hall, one of Proctor's buddies is on the defense witness list. Could they get the text in that way? Michael.
I thought about that, and I think that could work, because we know there are 5 people total on that buddy text chain. I think that's a way to go around Proctor. I think it's obviously more effective with Proctor because, you can get into he was lead investigator, now he's not. And how are you going to argue that the reason he's no longer an investigator or a trooper is not relevant to this case because it was his investigation of this case that lost him his job? I don't know the downside of bringing Proctor on. I don't know the downside.
Yeah, I'm rethinking Higgins too. By the way, here's the post for Tom CPU if you want to follow him in the morning. And Carla, free Karen Reed gifted 1 Justice Served TV membership. Thank you very
Carla,
much.
FKR.
Now that I'm thinking about it, okay, I said no, okay. But if you call Higgins, what do you need from Higgins if you're the defense? You need him to say some 6'2", tall, dark man with dark hair entered the house, right? You need that, right?
He said that.
He said that.
You need the fact, well, it hasn't come in now because he hasn't testified yet. He said that the last trial. And you need the fact that he threw away his cell phone on an Army base, knowing the order was coming, and got rid of his SIM card. Those are the two things you need from Higgins, right?
Yeah,
So
that's some of my favorite testimony.
That's and for Proctor, you need the tax, right? And the fact that he's fired and why he was fired, and the fact that he's lead investigator. What do you guys think of this whole idea that they fought off? What is the jury thinking about lead investigator? I mean, have you talked to people watching the jury in the courtroom, both of you, and see if they have any reactions to all this? I mean, they're fighting the stuff that's the stupidest thing I've ever heard.
Right. I mean, I would imagine any juror at this point is going to be like, who is this Proctor guy, and when are we going to see him, and why is he a former trooper,
I never heard of
thinking about it.
I never heard of ACA before this.
Well, the frustrating thing about all these text strings, too, is that we're all procured by the FBI. The jury will never know that either. We would never have these texts with Proctor.
That was what he was hoping.
Buddies if the FBI didn't hand it over in the TUI.
Right.
It's not like the defense was able to get Proctor's phone.
Right.
Yeah,
You're absolutely right.
There's no doubt about that. He never thought they'd see the light of day. No doubt.
Right.
Yeah. Madeira Beach caregiver says she has the edit in the making showing Higgins running to the car in the lot. So we're going to wait to hear that. Thank you, Madeira Beach. I'm glad that you were on this because you were really good. But yeah, you're right. They didn't. I think what the jury doesn't understand, and what didn't even come through on the first trial, and people are now understanding it, but it's still, the jury still doesn't have it, is that none of this, it wasn't like these people just said here, it wasn't like the prosecution said, oh, we're going to give you discovery. This is all as a result of the FBI investigation. And by not allowing them to hear the whole story, they don't understand the import of all this. And this is where I fault Judge Beverly Cannone. And I was willing to give her a pass and all initially, but she's allowing these misrepresentations, because they are misrepresentations by not telling this full story, to go before the jury.
Yep.
Well, this is all an abomination. This trial was never supposed to happen. And then when, U.S. Attorney at the time, Joshua Levy, dumped this 3,100 pages of TUI upon D.A. Morrissey's office, it was basically a daisy cutter bomb. Like it was supposed to make Michael Morrissey say, "Oh wow, we're going to give up on this case because look at what the FBI's been doing. It's been investigating my office, my troopers." But Morrissey is stubborn and he's just going forward with it. And now that all this FBI procured information has been injected into the trial 1 and now trial 2, a little less in trial 2. It's not even coming in as hot and heavy as it did in trial 1. But it must be confusing for a jury to grasp it all, like who Acker is and why does the defense have all these texts between these troopers talking bad about the defendant. If the jury isn't told, hey, all this information came through an investigation into this investigation, the jury, I think it just goes over their head.
Well, that's what I'm concerned about. I'm concerned about they do an Occam's razor and they say, oh, well, we don't understand all this because this case kind of went in strangely. We're in week 4. We're finally getting a cause of death that's and the manner of death is not homicide. And they say, okay, they just go, all right, well, Dewey, she drove.
Yeah,
I'm not
exactly.
understanding the importance.
That's what happened in trial 1, right? 6 or 8 jurors just said, she's guilty of count 2, I guess, and I'm going to go home. I've been here for 3 months. I'm done.
She was there. The body was there. He was found there guilty. That's what they thought.
And that's my fear in this version, that they're getting enough to get there on count 2. Yeah. But there's so many distractions along the way. They may never get there, or some will get there and some won't. And here we are, hung jury, mistrial. Cue up trial number 3. That's the worst case scenario.
That's what I think is going to happen. I swear to God, because if
that would be the worst case.
Grave concerns about something we know nothing about, and she had grave concerns. What he alluded to today about the Rule 14 motion, I think,
unbelievable.
I think they're going to I can't see it getting a fair trial. They can't go on. I just can't see it.
Unbelievable. How about the fact that Hank Brennan said, okay, we can call them in rebuttal. We'll call them in the rebuttal after this. Well, I mean, unbelievable. That doesn't give her grave concerns.
No.
She was a defense attorney for 24 years or 26
grave
years.
Concerns. Remember that? She cut the day short. I have grave concerns.
My gosh, she was apoplectic. She was breathing heavy. Her sighs were even more annoying than usual.
Everything on
Yeah.
that board's a grave concern.
Well, guys, we definitely appreciate your help. So let's wrap this up with one final guesstimate as to what's going to happen tomorrow. I will ask Tom first. What do you think is going to happen in the First Amendment zone?
Hopefully, I don't get arrested. I just want to go in, do my thing, and leave. That's all I'm looking to do. Really,
we're gonna be
simple.
using your stream, and I'll be following you.
Please.
Okay.
As long as it don't end up like
Linda, by the
Bow,
way,
I'm
says
good.
the feds are still watching, and yes,
They are.
I
know as a fact. Listen, I know as a fact.
They
As
are.
of Mother's Day, it was last weekend. There was a table next to me. Maybe we'll say, or we'll say that. And one of the people was working for a company that FBI is definitely active. They're very active. They haven't gone away. And Sandra is the reason that they're here. Remember
Sandra
that.
Birchmore. And
Remember that. That's she gets lost in this mess, and so isn't Justin and all the other people. So thanks for supporting us. We'll get there. It's just
I think Sandra Birchmore's birthday was yesterday, as I recall.
Yep.
I mean, yeah, right? Is that right? Yeah, or would have been. She would have been.
the guy murdered her and then went and gave birth to his son.
Yeah. Hey, gotta go. Just had time to squeeze in a strangulation, so it's outrageous. Okay, Scott, what do you think's gonna happen tomorrow?
Well, I have decisions to make because do I take my normal spot at the 200-foot zone where I know I have no problems, or do I park at the old 200-foot zone and see what happens?
Okay, here's a compromise for you that I'm not telling you to do. It's not legal advice, but what I might do, have my order with me, right? And especially the fifth provision for requesting review. And before you do anything different than you normally do, ask one of the troopers, how do you interpret this? If I do this, this, and this, what are you going to do? So you haven't done it, but you're saying, look, I'm looking for help here to interpret this. How are you guys interpreting this?
Well, we tried that today, but this was all so new, even to Sergeant Hardman.
Well,
he didn't quite know.
I assume they're having conversations. That's the least that they can do is be talking to somebody before tomorrow, full swing with the order in place.
He mentioned something about that, a meeting or whatever, so he can get up to speed,
Yeah. That'd be smart. So you could approach it that way. I mean, I might approach it that way. I'm not giving advice or suggestions, but Okay, guys, keep fighting the good fight.
Thank you for having us. We appreciate it. I appreciate it, and thank everybody that's
we
here.
have to
Give the
go-
thumbs up
yeah,
and the likes to these guys. They've earned it, man.
And you have to go to Tom's CPU's site here, and it's his YouTube site. And of course, before you go, hit the like and subscribe button here for Justice Served TV. Michael Bryan has gone up there, giving everybody, we try to give everybody a voice here because we understand their concern and how concerned we end up being the plaintiffs in the lawsuit. How do you like that?
Hi. Yeah, you're part of it.
Hi, we're here.
Welcome to Boston. Sorry. Charge with you.
Thanks for playing our game.
Linda, when you coming up? You're due for a couple charges.
I know. Michael's going.
Get her a felony or two.
Maybe if we can get a press pass, I'd love to be in the courtroom.
Oh,
I'd
good
love
luck
to.
with that.
Alan Jackson,
the most credentialed guy can't get a press pass. He's more credentialed than all the people combined.
Even if you get a press pass, you still have to win the lottery every week.
Randomizer.
I know. I was talking
They put Grant in there. This guy's got 5. He's got awards. They can put Grant in there.
They could give me a family. Alan Jackson, if you're listening, you can give me a family seat.
That's right.
Wouldn't it be great to have me and my husband in the courtroom the day that maybe your own medical examiner testifies? Wouldn't that be a novel? Or just me? You can give me a family seat. I can get in that way. Okay, that would be. Hello, anyone out there listening?
I might know.
We'll see.
We'll see what happens. I know a guy. We'll see, Linda. I know a guy.
I know a
guy.
And also, by the way, Center for American Liberty, let me put them up again. They've asked for any donations that you can give.
Mark Rendaza. He needs a big shout out before I go, too. He's amazing gentleman. What an amazing human that guy is.
Yep.
Yeah. But Michael's going to be up there next Tuesday and Wednesday, definitely. Tomorrow, I'm going to be handling the show my own self all day. I'll be on from, 8:50 or 8:30 in the morning till.
Say it like you're excited about it.
I'm worried about when I have to go to the ladies' room. What do I tell you all? What do I really give that out?
It's a close knit group.
Just go. Just go.
Just go.
Just go.
Okay, guys. Take care. Good luck tomorrow.
All right. Listen. Thanks, guys.
I'll see you all tomorrow.
All right. Bye.
Okay, so yeah, who knows what the hell is going to happen tomorrow?
But they were appropriately worried because they're
of course,
police.
Of course.
Yeah. If I were there though, I'd go in with a sign and just be quietly, because that's what started this. The quiet standing there protesting Beverly Cannone.
Yep. And then see what happens from there. But I've given some suggestions about what I would do. We'll see what happens. But you definitely have to be armed with that order, no matter what you decide
not armed,
to do.
armed with the
No,
order.
armed with the order. Yeah. Yes. So anyway, well, I appreciate you cutting me off tomorrow so I can get some family biz done. I appreciate that.
I know you're going to do a World in the World is Justice at some point on that, right?
I might have to. I'll probably have a few minutes here and there. I'll come up with something for the locale. Yeah.
But in the meantime, because you won't see Michael Bryant until probably lunchtime on Monday, but you have a lot of me. And I'm gonna keep pounding you all. Hit that like button. By the way, Missy says, "Can AJ get you a seat, Linda? He loves you. Remember, I don't know."
Right.
Hello, shouting
He
out
said,
there.
"Love you, Linda. Don't want to give you a seat. Love you though." There he is. He's over my shoulder.
Yeah, there he is. They're right there. Okay. Anyhow, so hit that like button, subscribe button, share. If you're watching us from Twitter, please come over to our YouTube site, become a subscribe, and hit our like button here. And we will see you tomorrow morning. I guess we're going to be streaming from 8:30 to follow Tom's CPU around. Missy, I hate to say that. Dizzy, I hate to say that. And I'll get on as soon as I can, and probably around 8:50 or maybe even earlier if I can get up there and get ready by 8:30. I have my own cases to do, and it's really forget them. That's what I tell my clients. Oh, can I get to this on the weekend? But they all love watching this case because they know that when they're in trouble, they want people out here like us watching what's going on to make sure the courts stay and the justice system stays honest. So, Michael Bryant, I know you have some words of wisdom before we go.
Yes. Good luck tomorrow. Have fun. I'll be tuning in as I can. And in the meantime, I'm Michael Bryant. Try to do the right thing.
I'm Linda Kenny Bodden. See you in the morning.
It's